When I tell y'all that Diddy is not going to trial on May 5th this year, I really do not think that they are going to be able to make it to trial on his criminal case on May 5th. And you may ask me why. It's because he is too busy filing any and everything other than focusing on preparing for his defense. And I'm assuming he's filing any and everything instead of focusing on his defense because he is filing any and everything. And there's no way, in my opinion, that they could be focused on their actual defense. Now, what I do think is why they're filing all these motions is to try to get a better idea of what the prosecution's game plan is when it comes to proceeding with these criminal charges against him. If you don't know what I'm talking about, you have not been following the channel, but that's okay. We are talking about Sean Diddy Combs. He is being accused criminally in the Southern District of New York for some federal crimes, including trafficking, including racketeering and conspiracy. And we're talking about drugs, we're talking about people, we're talking about all kinds of things that Diddy is being accused of. What was happening in this case a couple of weeks ago, because we haven't covered this case in a couple of weeks. What was happening in this case a couple of weeks ago is that Diddy had filed a motion to dismiss just one count of one of the superseding indictments, because there has been another superseding indictment. He is asking to dismiss that one count, and he is asking them to dismiss it because he is Black. And they are saying that they unfairly targeted him because he's Black. The prosecution eats him up on this motion. I'm telling y'all, they eat him up on this motion. And then he files another motion, but this time it's to suppress pretty much every single piece of evidence that the prosecution has already garnered against him, because he's saying that the prosecution did not fill out the request for the warrant properly, according to Diddy. Like, literally according to Diddy. I don't know where his lead attorney is getting off on, or is the lead attorney is the one telling him to file these motions. I don't know. But in my opinion, I think maybe he needs to focus on getting another lead attorney. He has already had an attorney quit. I see why. And like I'm saying, these motions that the prosecution is responding to, they're eating them up on them. If you missed where we talked about Diddy's actual motions, make sure y'all go and check that out, because we already covered his motion to dismiss the count on the superseding indictment, and we've already covered the motion to suppress the evidence that he's trying to get rid of because they didn't do it the way that Diddy liked. Today, we are going to be focusing on the prosecution's response and kind of predicting whether the judge is going to agree with the prosecution or agree with Diddy. At this point, I think that they're going to agree with the prosecution because the way they read Diddy and his attorneys, y'all are going to see why I think that they're going to agree with the prosecution. Now, another thing that has been going on lately is that Kanye West apparently released a song, including his daughter Northwest, who was like, 11 years old, somewhere in that range, a young child, while Diddy is being accused of all of these egregious things, with Diddy's voice on the recording as well. Kim Kardashian is not happy about it. And now we know we don't really like Kim Kardashian like that, and we really don't like Kanye West like that on this channel. However, there are some interesting things being brought up, including her claiming that she has the trademark, and including that Kanye West is not doing what is in the best interest of the child Northwest by putting her on a song with someone who is being accused of these horrible charges. I don't know if we're going to get to that today. I see Kimmy in the background. If you can put up a poll to see if the BriHive wants to cover that live, or would they rather me just put out an additional video like tomorrow? I'm probably still going to clip it if we do it live. I've kind of already skimmed it. And I think Kim Kardashian really needs to be talking to her attorneys, because she doesn't own the trademarks. And there's some nuance to that, which we'll get into either on the pre-recording that I'm going to release or later on in the live. But Kimmy, if you could put up a poll and see if the BriHive wants to talk about the fact that Kim Kardashian needs to talk to her attorneys because she probably doesn't own the trademarks the way she thinks she owns the trademark, so that we can see if we want to cover that. But anyways, that was a long intro for today. I had a lot of words, a lot of things to say, a lot of things going on in this case, but let's go ahead and jump into which one is going to be the best. Let's go ahead and jump into Diddy's motion to dismiss the one of the counts in the superseding indictment. Let's go ahead and have Bossy B bring us into that. Oh, that was strange. Why could I not hear that? Why could I not hear that? I had some technical difficulties earlier, so I don't think I'm set up properly on this. No, that's not it that I need to do. I think this one. Maybe. Let me try this again because y'all had some technical difficulties earlier, and I don't know if y'all could hear that. I don't know what's wrong with that. We are going to I'm gonna have to figure that out later. But if y'all couldn't hear Buzzy B buzzing across the screen, luckily we don't have any videos today, but I got to figure out what's going on over here on the soundboard at a later time. But like I said, let's actually go ahead and jump into Diddy's motion to dismiss. Just count three of what is already going on in the indictment. And like I said, the prosecution, the state, the government eats Diddy's attorneys up. Like it's ridiculous. It's ridiculous the way they call them out about halfway doing their job. And like I said, I think he might want to start looking for a new lead attorney. And I don't think that this thing is going forward on May 5th. So let's go ahead and jump in. If you recall, Diddy filed a motion to dismiss just one of the counts of the superseding indictment, including where he engaged in commercial adult activities with men across state lines. And Diddy's his reasoning for why he thinks that the prosecution just brought that one particular count against him. Mind you, there's 3 counts against him with 3 different victims against him and all kinds of other stuff. But he's saying they brought that particular thing against him because he was Black. And you know, this is like the second time he's pulling the Black card within the last year. And I really don't like that. I don't like it. I don't like it at all. Let's go ahead and see how the prosecution basically eats him up. Let's see. I don't got it together. Y'all, my Wi-Fi cut off earlier. So look, we're not even prepared, Bree. We're not even sharing the screen. So let's actually try sharing the screen. That would be helpful. And then we'll go ahead and read the document. And Kimmy is saying she could hear the buzz. It wasn't coming through my earphones, so I'm not sure if you're hearing it just from my computer screen speaker or if you're hearing it from the stream, but I'll check that later. Okay, let's get into it. I've been rambling today. We're going to talk about it, okay? So, preliminary statement, or let's actually add this to the stage, Bree. Let's get it together. Y'all might see me looking to the side. I am also on TikTok today, streaming this stuff, so if y'all see me messing with stuff on my phone off screen, that's what I'm doing there. So this is the prosecution responding to Diddy, saying that y'all brought this claim of me engaging in commercial adult activities with men only because I am Black and y'all are trying to embarrass me. And there was some other people that did the same thing as me, but y'all didn't press charges against them. The state, the government is like, we're not doing that, Diddy. We are not doing that. And the government respectfully submits this memorandum of law in opposition of defendant Sean Combs' motion to dismiss count 3 of the indictment in this case, offering no more than his say-so. A lot of what Diddy is complaining of and saying that the prosecution is doing wrong is because he's like, I don't really like the way they did that. I don't really like that the facts that they included don't include the facts that I think are relevant. It doesn't work like that, Diddy. So let's go on. The defendant makes the outrageous and illogical claim that federal prosecutors brought one and only one of the 3 charges against him on account of his race. Tellingly, the motion fails to mention that the other counts of the very same indictment allege that defendant engaged in horrific and repeated acts of violence and sexual coercion, harming multiple victims over the course of multiple years. That context alone defeats the motion. Count 3 charges conduct overlapping and intertwined with the years of violence, abuse, and exploitation alleged in counts 1 and 2. Defendant's baseless accusation that he was singled out on account of his race are false and fall short of the rigorous standard required to make a prima facie case of selective prosecution, race did not factor in any way into defendant's charges. On the contrary, as set forth in the indictment, the defendant was charged solely because of his own violent, abusive, and criminal conduct. The motion should be denied. Now, what I see Diddy doing, like I said, I feel like he's trying to distract us and say, oh, well, look, this is going to get dismissed because of this reason. This is going to get dismissed for this reason. I think another thing that he's trying to do is like, I really need to know what y'all strategy is because I don't really know what my strategy is. So can y'all please help me out here? See what the government knows, and we're going to get into that in the motion to suppress as well. I feel like he's trying to figure out what the government knows so that he can try to make a better case for himself, if that makes sense, okay? And what he's also doing in filing all of these motions, instead of focusing on getting through the evidence, the terabytes and terabytes, and what they say, like 40-something terabytes of evidence that they have against him, instead of actually working through that, his defense team, they're filing these motions and giving the prosecution and the court, or giving the prosecution the opportunity to throw shade at Diddy, giving the prosecution the opportunity to give more information to the court. So now the court is probably going to be more annoyed with the defense team once it actually goes to trial. I don't think this is helping them, but let's get further into it. Y'all let me know what y'all think. And if you're on YouTube, you know that we have a poll up asking y'all if y'all want to go into the whole trademark issue with Kim Kardashian and the owning of Northwest's name and how that might become an issue for her a little later on. So make sure y'all are checking in on that. And then so that's what we're getting. Give me 1 second, y'all. So you are saying that it's echoey. Okay, we got to have a, because if my thing is echoey, we don't want bad audio for this live stream. So let me see here with our setting. Oh, that's what it is. We're not even on the right audio. Oh, thank y'all for calling that out. Are we even connected? Why is this not connected? I'm not even finding it. All right, y'all. We are in. We're not even connected to the right mic. I'm like, we're not even connected to the right camera, I don't think. No, we are connected to the right camera. What's going on, Bree? I was having technical difficulties. This is what happens when you live stream. Did not even know that was about to be a problem here. So let me try to get my audio back. My Wi-Fi had like disconnected from the my Wi-Fi had disconnected from the computer, and now all of my other junk on the computer is messed up. So thank you. Who said my volume? Gabrielle said it's kind of echoey. Thank you for that. Let's see if we can get the right freaking microphone that I paid so much money for to work. Okay, it's saying that it's working now. Let me know if it is still echoey for y'all. Let's see. I should be able to hear the echo if it is echoey. Let's see. See, Bossy B. I'm still not able to hear that, but that's because of that. So let's try that again. We are good on that. Are we better on the audio? Are we better on the audio? Y'all let me know. We are apparently back on the right microphone. Okay, Kimmy is saying that the mic still sounds off. I don't know why. But we're back on the proper audio. Well, that wasn't fun, guys. I'm wondering if it's because I do have the other one on. Ms. Howardson think it sounds good. So we're going to leave it for where it is right now. And I will dive into some other stuff as long as I'm not like staticky or anything like that. If it's echoey, maybe more because of my voice versus the microphone, but I will double check on that a little later. Let's actually get back into the content. Let's get back into the content. Okay, Gabrielle Joy says, okay, so there might be something wrong with the mic. We'll figure that out at a different time. So let's go ahead and jump back into the documents. The prosecution talking about how Diddy is all off course right now. He's off course, okay? Y'all, I'm gonna have to cut that out, but that's okay. Anyways, on January 30th, 2025, a grand jury in this district returned an indictment charging the defendant in 3 counts. Count 1 charges defendant with participating in a racketeering conspiracy between or in or about 2004 and 2024 in violation of a statute. We also got, among other things, count 1 alleges that defendant coerced 3 female victims identified in the indictment as victim 1, victim 2, and victim 3 to engage in commercial adult activities. The indictment alleges that some of the victims were coerced to engage in commercial adult activities that sometimes lasted multiple days and often involved multiple male commercial workers. Count 2 charges the defendant with ST, trafficking for adult activities, victim 1 by force, fraud, and coercion between in or about 2009 and 2018 in violation of the statute. Count 3 charges the defendant with transporting multiple individuals, including the same sex trafficking victims identified in count 1, victim 1, 2, and 3, and male commercial adult activity workers interstate for the purpose of engaging in prosecution. We're just going to say it and hope YouTube doesn't get mad at us. Between in or about 2009 and 2004, the indictment provides detailed factual allegations describing the defendant's year-long pattern of criminal conduct involving abuse and exploitation of multiple victims. That conduct included a persistent and pervasive pattern of abuse towards women, including verbal, emotional, physical, and sexual abuse that spanned years. The indictment describes the transportation of both women and commercial adult activity workers, workers, as intertwined with the defendant's coercion of women to participate in orchestrated performances of sexual activity by distributing narcotics to them, controlling their careers, leveraging his financial support, and threatening to cut off the same, and using intimidation and violence. The defendant's violence included striking, punching, dragging, throwing objects, and kicking women on numerous occasions over multiple years. The defendant used his vast resources and business empire to carry out, facilitate, cover up his acts of violence, abuse, and commercial sex, enabling the defendant to continue his criminal conduct for years. As alleged in the indictment, the criminal activity included violations of multiple federal laws, including forced labor in violation of the statute, sex trafficking, the transportation to engage in prostitution, and the violation. These allegations are included both in racketeering conspiracy charged in count 1 as racketeering activity and in statutory offenses charged in count 2 and 3. And that's just including everything we went over. The indictment thus makes clear that the transportation alleged in counts 3 served the defendant's abuse. The indictment thus makes clear that the transportation alleged in count 3 served the defendant's abuse of victims. That count alleges that defendant transported the same victims identified in earlier paragraphs as victims of abuse. That count also alleges that defendant transported commercial sex workers, which corresponds to the allegations in earlier paragraphs of defendants coerced female victims to engage in sexual activities with male commercial sex workers. All 3 counts of the indictment thus, on their face, charge a common course of conduct arising out of the defendant's abuse and sexual exploitation of multiple victims. So, although Diddy is saying, well, you guys should drop the count about me engaging with male sex workers because y'all don't charge anybody else with that, and y'all are only charging me because I'm Black. In filing that motion, Diddy gave the prosecution the opportunity to say, no. What we charged you with was this. This is a problem, and this is why it's a problem. And let's re-explain to the court why we have all of these issues with the things that you were doing. Okay, I was just trying to check if there was any other issues with the audio there. So let's go ahead and jump into what's actually going on. Remember, Diddy's only defense is y'all are charging me because I'm Black. That's it. He has the burden of showing that the prosecution did something wrong and that there were other similarly situated defendants in which they could have brought these charges against, but they chose not to because of race. The thing about this is that it doesn't really seem like Diddy's attorneys really do a lot of research when they're filing these things. They just kind of file them, and then they hope that the prosecution either like just doesn't respond on time or they don't know what they're talking about. I don't know what they're hoping. But the thing about the prosecution is like they're the one prosecuting people for these. So they're going to have a database of cases recently charged or charged within the last couple of years that are similar to what they're charging Diddy for. While Diddy, on the other hand, is more going to have to like go through court cases, see if they actually apply, maybe even go through some type of legal database. But they're not going to have what this actual team has prosecuted in the last several years. And so we go on. I don't know what they expected them to respond, but they respond nonetheless. So let's go ahead and see what the prosecution has to say about Diddy's allegations. We're going to jump around a little bit in this. I did not have time to read this today. I read it like last week. So hopefully we don't mess up too much, but let's get into why the prosecution is saying that Diddy is going to fail on his argument that they got him just because he's Black. Okay. So the motion fails to meet either prong of the required standard to support a claim of selective prosecution. The defendant spills much ink detailing the origins of the statute charged in count 3, but he cites no law indicating that the legislative history of a statute has any bearing on either prong of a selective prosecution claim, and he makes no attempt to connect that history to the applicable test. We talked about this when we were actually covering the document. It's like, why does all of this matter? He's going into the history. He's saying that it was particularly against Black people. I forgot what he related it to, but it was particularly to prevent Black people, Black men from marrying white women. And he went into that whole history. And we're like, okay, we're like 3-4 pages in. Why are we still talking about this? And I think the prosecution did a wonderful job in calling him out and saying he spilled much ink. Yeah, he wrote a lot about that, and it had nothing to do with, okay, what are the charges against you, Diddy? We're not talking about the history. We're talking about the charges against you and how the prosecution wronged you, okay? Stripped of its overheated rhetoric, the motion presents neither evidence that other similarly situated individuals were not prosecuted, nor evidence that the prosecution was undertaken in bad faith. That is because defendant's theory of selective prosecution has no basis in reality. Race played no role whatsoever in the decision to seek the charges contained in the indictment, which instead stemmed from defendant's decades of criminal conduct. Because the defendant offers nothing more than conjecture to suggest otherwise, the motion should be denied. So he filed this basically to try to get a hearing, and he basically didn't give y'all no facts. So why are we even here? Why are we even needing to respond to this? Is basically where the prosecution is now. Let's get into their first step. The defendant fails to show that similarly situated individuals were not prosecuted. They're going to remind us of what he claimed, which was he read some articles that other rich white men engaged in commercial sex and other people hired the commercial sex workers because obviously they're in business. So people are clearly using their services, and those people should also be prosecuted. But the prosecution does a good job as to why that is not a strong argument. So let's look into that. So with respect to the first required prong, the defendant must show evidence that others similarly situated have not generally been proceeded against because of the conduct of the type forming the basis of the charge against him. A similarly situated offender is one outside the protected class who has committed roughly the same crime under roughly the same circumstances, but against whom the laws have not been enforced. Let me see here. Here, to the alleged discriminatory effect, the defendant relies on 3 examples taken from media articles. Elliot Spitzer, Jerry Falwell, and unnamed clients of the escort service that defendant used at times in connection with some of the charged conduct. As an initial matter, none of these individuals is similarly situated to the defendant. The motion misleadingly suggests that anyone who has ever hired an escort is similarly situated to the defendant, but that characterization ignores the aggravated factors presented in the defendant's case that are not present in mere hiring of an escort. First, the defendant violated the Mann Act. In the course of sex trafficking, multiple victims, forced, fraud, or where was I at? First, the defendant violated the Mann Act. In the course of sex trafficking, multiple victims through force, fraud, and or coercion. The indictment's allegations that the defendant coerced multiple victims into commercial sex acts, including with the male escort, who are the subject of count 3, set the defendant in stark contrast to the examples he cites in his motion. There is not a hint of trafficking or coercion raised in any media coverage that defendant cites regarding Spitzer, Falwell, or the other clients of the escort service the defendant used. That absence of trafficking allegations, similar to those against the defendant here, defeats any suggestion that those 3 examples represent similarly situated individuals. So essentially, he was like, but those people do little nasty adult things and hire people to help them do it, so they should be prosecuted. Prosecutors are like, no, they aren't being accused of forcing anyone to do anything. We're not going after you because you hired escorts. We are going after you because of the manner in which you hired the escorts and the manner in which you made these people engage in these sex acts with these sex workers, allegedly. Okay, let's go on. Second, the defendant carried out the transportation of victims and the use of force, fraud, and coercion to cause those victims to engage in commercial sex acts as part of the broader pattern of the racketeering activity. The Mann Act allegations stand together with other racketeering predicates, including not only sex trafficking, but also arson, narcotics, distribution, bribery, and obstruction. All of this conduct, which was overlapping and pervasive, furthered the twin goal of feeding the defendant's personal desire while also protecting and even building his reputation. The defendant used his wealth and power to build an enterprise characterized by violence against victims, employees, and rivals alike. And he used the same enterprise to find the transportation of victims and escorts in violation of the Mann Act. Nothing in the motion suggests that Spitzer, Falwell, or the other clients of escort service transported escorts as part of a pattern of racketeering activity, and that they committed any other crimes whatsoever during the same period when they engaged in the commercial adult activities. The distinction further widens the already vast distance between the defendant's conduct and the example he raises in his motion. Third, the motion conveniently ignores the allegation that the defendant violated the Mann Act not only by transporting the male escorts, but also by transporting 3 victims of trafficking. Examples of other individuals who may have paid escorts but were not involved in the transportation of victims of trafficking are thus inapt. Count 3 charges the defendant with transporting victim 1, victim 2, and victim 3, as well as male escorts for the purpose of commercial adult activities. None of the examples cited in the motion involve the transportation of victims of coerced commercial sex, in addition to the transportation of escorts, revealing the absence of yet another aggravating factor from the defendant's proposed comparators. So essentially, you can't just say these people hired escorts, so you shouldn't charge me for hiring escorts. It's like, we're not really coming after you for hiring escorts, Diddy. We're coming after you because you hired escorts, you took them across state lines, and you forced 3 women to engage in sex acts with them through violence and coercion and force, allegedly, is what the prosecution is accusing Diddy of doing. That's why we're coming after you, not just because you're into male sex workers. We don't really care about that, okay? That's not why we're coming after you. And we definitely did not consider the fact that you were Black in making these allegations against you, Diddy. Like, you are being accused of far worse things than just hiring male sex workers. Like, does he not read the whole indictment? Do they just find one thing that they find a problem with and just cherry pick it? And they're like, yep, we're going to go with this one today. I see why that other attorney got off this case, because it's going nowhere. It's absolutely going nowhere. Fourth, the defendant points to nothing establishing that his proposed comparators even satisfy the elements of the Mann Act. The defendant fails to cite any evidence demonstrating that Spitzer, Falwell, or other clients of the escort service transported anyone across state lines. He did not talk about that either. They are right, for the purpose of commercial sex. And there is no indication that Falwell even paid anyone to engage in sex acts. Rather, the article cited in the motion simply suggests that a third person consensually participates in sex acts with Falwell and his spouse. And that was another thing. In Diddy's motion, he indicated that the purpose of the escort service was not sex. They don't sell sex, they sell companionship. And if the consenting adults decide to engage in sex later, that's not something that's actually advertised, although the escorts tend to get freaky. This is probably not the best thing to say on YouTube, but they tend to do that. They tend to do that, but that's not what they're selling. Diddy himself put that into his motion. So that's not what you're supposed to be buying. You're just taking it that step further and doing it anyways. And even these articles, there's no saying of if they're doing it with those particular escorts. So I just wanted to point that out too. Far afield from the example cited by the defendant, a similarly situated individual to the defendant would be someone who engaged in violence and coercion as part of a pattern of racketeering activity and who transported not only escorts but also victims of the violence and coercion. Because the defendant's alleged criminal conduct is considerably more serious than anything he accuses these individuals of, he has failed to identify any similarly situated individuals who were not charged. This is fatal to his claim. Okay. Moreover, the defendant's allegation against the unidentified individuals lack evidentiary support as they are based entirely on his interpretation of public reporting. Such hearsay and anecdotal evidence is insufficient to meet a defendant's burden, even to obtain discovery on a selective prosecution claim. So you read an article online and said they were not charged. Who even said they were in the running for consideration to be charged? Sir, this is just an article. This is not something that came across the prosecutor's desk and they said, oh yeah, we're not going to charge him because he's white. Like none of that happened, Diddy. None of that happened. So let's keep going. Here we go. The defendants cannot meet his burden on a selective prosecution claim merely by making unsupported allegations about a handful of individuals and claiming that they should have been prosecuted too. Those shortcomings defeat the motion, but it also bears noting that the motion does not argue that the entire indictment is selective. Only the inclusion of count 3 is so. A similarly situated individual would thus be one who is also charged with racketeering, conspiracy, and ST, but for whom prosecutors declined to charge the Mann Act. The defendant can cite to none. Indeed, there are several recent cases from the district alone in which the government charged defendants of varying races with the Mann Act in addition to ST, including the prosecution of wealthy fashion executive Peter Nygaard, a white defendant who was charged in this district with racketeering, conspiracy, ST, and Mann Act violations. I think that's also the same person he cited as to, well, he got out on bail, so why couldn't I get out on bail? There was someone, I can't remember if it was them. This is consistent with numerous other indictments returned in this district charging Mann Act violations together with ST charges. I think they should have just looked up all the Mann Act violations. Because even like you couldn't find that. You couldn't find that before you filed it. And with frequent use of the Mann Act to prosecute defendants accused of SA. These examples demonstrate that prosecutors in the district routinely charge the Mann Act with aggravating factors, including trafficking and other exploitation, where other trafficking and other exploitation are present. And if anything, the defendant's case presents uniquely serious aggravating factors given the extensive violence and abuse alleged in the indictment that violated federal racketeering, trafficking, and forced labor statute, among others. At the bottom, contentions that a handful of individuals were not criminally charged out of the millions of individuals who reside in or are otherwise subject to potential prosecution in the Southern District of New York are plainly inadequate to meet the requisite threshold to demonstrate discriminatory effect. That's another thing. He pointed out these articles. Where do those people even live? He didn't go into any of that, okay? So Diddy is just not working out for you at this point. The defendant fails to cite even a single case in which a court has ordered discovery on selective prosecution claims based on such tenuous allegations, and the government is aware of none. The lack of precedent supporting the defendant's position is not surprising, as any such finding would defy a strong presumption that prosecutorial decisions are proper by allowing the exception to swallow the rule. The defendant has failed to offer any evidence whatsoever of a similarly situated individual to demonstrate discriminatory effect, and his motion should be denied on that basis alone. So that is lovely, Diddy, that you don't think that you should be the only one charged with this. But this prosecution team has cited other cases recently in this district that they charged with similar aggravating factors, but definitely not aggravating factors to the extent of yours, but showing people of varying races have also been charged with this. So Diddy, it's not because you're Black. I know it sounds like a good card to pull, but it's not always the best card to pull. Let's go on to the second prong that Diddy does not meet in this case. So the defendant fails to show a discriminatory purpose. Because the defendant fails to make an evidentiary showing in support of the first required prong, his motion must be denied. But even if the court were to assume arguendo that defendant had made such a showing, his motion still fails on the second prong because the defendant cannot present any credible evidence that would suggest, let alone establish, that the charge in count 3 resulted from any defamatory purpose. As discussed above, the second required prong is discriminatory purpose, meaning the defendant must have been selected for prosecution based on such impermissible considerations as race, religion, or the desire to prevent his exercise of a constitutional right. To prevail on his claim, the defendant must show more than discriminatory conduct. Generally, he must demonstrate that the government, in his case, acted with a discriminatory purpose. While the defendant slings accusations of racism throughout his motion, he identifies no actual evidence. Indeed, apart from speculation and conclusory assertions, the defendant cites no evidence to make that showing, nor could he, because race played absolutely no role in the decision to charge the defendant. Remember, he is being charged with transporting 3 different victims. Okay, well, he's being charged of distributing drugs. He's being charged of having weapons with their serial numbers scratched off. He's being charged of having terabytes of data of him engaging in inappropriate sexual conduct and illegal sexual conduct. You have all these charges against you, and it's not because you're Black. It might be, Diddy, because you're Diddy. You might say it's because I'm Diddy and y'all want to finally get me on something. Maybe you can do that. But because you're Black, that one's just not going to fly. It's not going to fly here. Anyways, let's go on. The motion claims, without citing any specific example or evidence, that the government has gone out of its way to humiliate the defendant and to prejudice the jury pool by pretrial publicity that plays on racist tropes. Now, what I will say, and I've been saying throughout this case, Diddy is fighting this case in the media by filing all these motions. I don't think he has any basis for filing any of these motions. I highly doubt we're going to make it to a hearing based on these motions. Okay? Even in his motions, it just said, you should find this or just give me a motion. In both of these motions that we're covering today, y'all should find that they did something improper or give me a hearing. You want a hearing so that it can get more media coverage. In my opinion, that's what's happening. Y'all can let me know if y'all think differently. But for me, I think that he's filing these things to get more media coverage on this case. A lot of people aren't even covering this case within this sector, all the attorneys that cover lawsuits on online. I haven't seen a lot of people actually covering the case. So I think he wants a little bit more attention, and he keeps saying the prosecution is trying to tank the jury pool. I think Diddy is. To file a motion saying you filed this one count out of all the other counts, you filed this one count against me because I'm Black. Okay, well, what about the other 2 counts? What about everything else? Okay. It just doesn't work. It doesn't work, and I think he is wasting time, and he's trying to get more information from the prosecution. So let's go on. To the extent that this refers to the press release and press conference held upon defendant's request, I missed this. To the extent that this refers to the press release and the press conference held upon the defendant's request, the defendant does not explain what racist tropes the former U.S. Attorney Damian Williams supposedly used when announcing the charges. The September 2024 release and conference fully complied with the local rules. Since then, the U.S. Attorney's office has not made a single comment to the press, including when obtaining a superseding indictment. The only person bringing this up, come on now, who's the one putting this in the media? I think it's going to be Diddy, y'all. I think it's going to be Diddy. The press release and conference in connection with this case were consistent with the former U.S. Attorney's approach to many other cases charged under his supervision, including the prosecution of white defendants. See examples of Elon Alexander, Orrin Alexander, and Tal Alexander charged in Manhattan federal court with the ST offenses, just like Diddy was, okay? And then there was another one with Senator Robert Menendez, his wife, and 3 New Jersey businessmen charged with bribery offenses. Same kind of titles on the releases is what they're basically getting at. Nothing about the announcement of charges in this case reflected racial bias, not to mention a discriminatory purpose in charging count 3. Just count 3, not everything else. Everything else is fine, okay? This case rejected selective prosecution claim and noting there is nothing unusual about the U.S. Attorney issuing a press release announcing an arrest, and the press conferences are conducted with regularity in this district. The defendant's remaining accusations fare no better. First, he offers nothing more than his say-so that prosecutors have leaked anything at all to the press. The motion fails to even identify the supposed leaks, provides no evidence that any such leaks came from prosecutors in this case, and offers no explanation of how any supposed leaks reflect discriminatory purpose in charging count 3. Indeed, the defendant was previously denied relief in connection with such purported leaks by this very court. He did say that the prosecution was leaking stuff, and the court basically was like, no, they put the restraining orders in place, and there really hasn't been any talk about any further leaks. He tried to appeal, or he tried to ask for certain things to be suppressed because of these alleged leaks multiple times. All of his motions are being denied. Like, he has not been successful on any substantial motion that he has made, in my opinion. Y'all can let me know if I'm wrong or if I'm missing something, but Diddy has not been doing well anytime that he's filing any of these motions, because I think a lot of it he doesn't have a basis for. Second, the defendant complains that he was not permitted to surrender and was instead arrested by federal agents. But the decision not to permit a defendant charged with committing violent crimes, engaging in obstruction, and sexually exploiting victims is entirely consistent with the practice of the U.S. Attorney Office in other cases, and again does not provide any basis to infer racial animus with respect to count 3. And then they cite the same case, the one against Alexander, then there's one against Paddock, and there's one against Maxwell. Indeed, that decision was technically approved by 3 different judges in this district, denying the defendant's repeated bail applications and finding that he poses a danger to the community. Remember, he tried to get released on bail multiple times. Multiple judges said, no. You are a danger to the community. So the fact that they arrested him, rather than letting him turn himself in, because remember, the defense team was reaching out to the prosecution saying, hey, let us know when you're going to arrest him so he can just turn himself in. Let him know. Like, you don't run things. I think that's something he is not understanding, is that, Diddy, you don't run things. You don't get to tell the U.S. attorneys how they're going to arrest you. Now, could they give you the option to turn yourself in? Sure, they can, but that's their choice. It's not your choice. It's not your choice. So you feel embarrassed because you were arrested. I mean, shouldn't we also feel embarrassed of the crimes that we're being accused of? He's claiming he didn't do it. He claimed he didn't do it. But come on, y'all. Do we think that the federal government is going to file these charges against Diddy if they don't have evidence? Like I said, it's a complaint. These are allegations. Nothing has been proven to be true. But I think he's a little bit afraid of the evidence that's going to come out, and that's what we're going to cover in the next motion, the motion to suppress evidence. All the evidence. He wants to suppress all the evidence, every single thing that they collected from his house. So, Diddy, what evidence do you want them to have? None? No evidence, right? Yeah, I I don't know who's filing these motions. Let me finish this so that we can jump into the next motion. Third, the defendant repeats his prior complaint about the manner in which search warrants were executed at his home. That argument ignores that the warrants were executed not by prosecutors in this case, but by law enforcement agents who are not the subject of selective prosecution claims, setting aside that the use of force to secure the premises, especially when the crimes under investigation include violence, and the items to be seized included firearms, is entirely justified. Yeah, like, don't you remember those guns, Diddy, that you scratched the serial numbers off of? Yeah, the way they secured your home was not outrageous in my opinion, but let's go on. Let's see. It certainly does not demonstrate discriminatory purpose when electing to charge count 3. You had illegal guns in your house, sir. And you have security guards that potentially use those illegal guns. So we have that. Unsurprisingly, the defendant cites not a single case to support his suggestion that the vague accusation he makes are sufficient to show discriminatory purpose. Further undercutting his position, courts routinely reject speculative selective prosecution claims like the one raised in this motion. The defendant's unsupported accusations of discriminatory purpose by the prosecutors handling this case is simply a desperate attempt to shift the focus away from his actual criminal conduct. The defendant's own violent and abusive crimes result in his prosecution. Nothing more. Nothing more. We charge you because people said you did bad things and we believe them. In sum, the defendant has failed to adequately allege that there was anything unusual, let alone improper, about the charging decision in this case, because his allegations fall far short of the rigorous showing necessary to make a prima facie case warranting the disclosure of discovery, much less of the clear and convincing standard required for dismissal of count 3 for selective prosecution. His motion should be denied, and we don't need a hearing. Okay. Shout out to Mr. Matthew Podolsky. Okay. He ate him up. If he's the one writing this, if it's younger attorneys writing this for him, he ate him. The whole response to the motion was Diddy tripping, Diddy tripping, Diddy tripping. He gave no evidence. He's just spewing nonsense. And we're saying Diddy, but it's his attorneys. These attorneys are just spewing nonsense and trying to, in my opinion, trying to get more attention on the case. Diddy, we did not charge you with one count, mind you, one count because you're Black. The other two are good, right? The other two are good. But this particular one is because I'm Black. Sir, this particular one is connected to the other two. So how are those ones not because you're Black? You can't pull the race card on everything, okay? You're saying that the Mann Act was put into place to stop Black men from marrying white women. You are a Black man. We will give you that. But the Mann Act and how it applies to you is you engaging with male sex workers. So those are not even women. When you're saying the purpose of it was to stop Black people, well, it was also to stop you from getting with white women. This is we're talking about men here, okay? So that fails, and you don't even give us the race of the sex workers. So, like, come on, like, I don't know who is giving them the idea to file these motions, but whoever is in charge of the motions that they're filing needs to sit down. And like I said, maybe they're trying to buy more time. Maybe they're trying to distract the public. But sir, you have so much evidence to go through that you're not going through. This motion was not going to get you where you need to be. Make sure y'all are letting me know your thoughts on the case. And actually, because the next motion is so long, I'm going to go ahead and go through the comments regarding this case. So if y'all have thoughts, make sure y'all are putting them there. If you're on YouTube, we have a poll to determine whether we're going to go over Kim Kardashian's trademarks and claiming that she owns Northwest name, so that this song that Kanye put out with Diddy's voice on the same track as her minor child, we're going to talk about how her little trademark is going to pose an issue for her, and she should probably talk to her attorneys, because it looks like most people on YouTube are voting yes, that you do want to look into Kim Kardashian's trademarks, because who doesn't want to be nosy in celebrity trademarks? I do. I kind of skimmed them, but I haven't looked super deep into them. So let me go ahead and actually check out some of these comments because the motion to suppress the evidence is going to be a little bit long and I don't want to forget where we are right now. And hello and welcome to everyone that is watching live. If you're on the replay, also hello and welcome. Please do, if you haven't already, hit the like button. It does help us out in the YouTube streets. And actually, we are already at 23 likes. So shout out to the BriHive with 21 people watching live. But if you haven't hit the like button, please do. It does help us out on the channel. So we have Deacon Fatal, member and moderator of the channel, saying, when a lawyer leaves a case like this, I would have questions. And yes, comedian brought this up with the comparison. And the way that that attorney left the case was quick, fast, and in a hurry, and he had to request the court to take him off the case. Generally, when you have to request for the court to take him off the case, it's because there is some issues happening with your actual client. In my experience, that's what it has been. Not saying guaranteed that it's Diddy's and Diddy is being an a-hole. Not saying that's what it guaranteed is, but in my experience, it is usually a problem with the client because the client can sign you off of being their attorney without there being any necessity to file anything with the court. So his attorney left quick, fast, and in a hurry, and right around the time that they filed this motion to dismiss count 3 because he's black. Well, what about the other 2 counts? Y'all don't care about those? Those ones aren't because he's black, huh? Deacon Fatal says to me, would he be trying to get more media attention to move the venue? No, he's not trying to move the venue. He just wants the whole case dismissed. And he keeps saying that the prosecution is trying to taint the jury pool. I think that he's trying to taint the jury pool. If there was an issue with venue, there would have been some motions. But no, I guess that could come into play later because if you go to trial and you try to select the jury and you say, oh, well, this has been too tainted, we need to move somewhere else, kind of like in I think this was happening in Brian Kohlberger. It could be a reason later on down the line, but I think I don't think that's a smart move. He's an international celebrity. Wherever you move him, people that are paying attention to the case are going to pay attention to the case no matter what state they're in, right? Just Me MD says, part of me also believes out of sight, out of mind is at play. Keeping this case in the forefront of people's mind is working both for him and against him. 2 things can be true at once. I agree with that. I think that he strides in effect negatively, right? You're calling attention to this case to say, oh, black people, because that's who we always call on, right? Black people be on my side. They're coming after me because I'm black and I engage. I don't know why he thought this was going to give him any sympathy, but I engage with male sex workers and I'm black and they coming after me because I'm black. And I'm like, well, did your attorneys do any kind of research? Because the fact that the prosecution was able to list 3 recent cases and you didn't see those cases when filing this motion, and the first one they list is of white people being charged with the same thing you're saying that they're going after you for being black for. And the fact that you're saying, yes, only this one is brought against me because I'm black, but not the other 2. Like, yeah, maybe I sex trafficked my girlfriends. Maybe I did do that. But engaging with escorts, you only coming after me for that. That's probably the least of your worries. Hiring escorts is probably the least of his worries. And not only is it the least of his worries, he has now admitted that he did it. He's now admitted that he's taken commercial sex workers across state lines, violating the Mann Act. He's admitted to that, but there was a hearing, I think on like March 14th or something, where he pled not guilty to the crime charges. Because I'm like, but you already admitted to this one. So yes, he is keeping it in the media, or trying to keep it, because like I said, a lot of people are not talking about this case. I am very surprised that it's not getting as much coverage as I thought it would get, but also maybe people are just tired of Diddy and they're ready for him to disappear. Like even the whole controversy with the Kanye West, with Northwest on the song, that controversy, that didn't even stir up, at least in my TikTok, and I watch TikTok and ashamedly, I watch TikTok all day pretty much, and I didn't see a lot of it. I've seen a couple of people popped up talking about it, and it's almost like, okay, well, enough people are not paying attention to Diddy, in my opinion. Enough people are not paying attention to Diddy, so let's throw another wild card in there. Let's throw Kanye West in there and some Kim Kardashian drama. As soon as you throw Kim Kardashian's name out there, people are going to pay attention to it. People outside of just Black people, remember? Because, hey, Black people be on my side for charging me because I'm Black. Black people didn't bat an eye at that. They didn't pay attention to it. And so now we're releasing a song with Northwest on it. Of course, that's going to pull Kim Kardashian's name in it because she's sending these desist letters and seeing what she owns and what she's in charge of and what Kanye West knows. And we already know Kanye West just out there, right? His name is in the media. He's always the wild card. Let's put some more drama on it. And again, I don't even think that garnered as much attention as they thought it was going to garner, right? Putting him in this song and trying to call more attention to it. So y'all let me know, did y'all see a lot of the stuff about the song? I really didn't. And my For You page is very geared, very Black creator filled on TikTok. So I feel like I should have seen a lot more of that, but maybe they're not trying to really get our attention with that, with trying to get this case more attention. And that's my opinion. I don't know if that was the reason for releasing the song, but I do think that it has some type of connection to it. Deacon Fatal says, I think they are trying to buy time. They're going to have to. There's no way that this is going to trial in less than 2 months. There's just no way. The fact that you even filed a motion to suppress the evidence, there is no way that this is going to trial in less than 2 months. I just can't see it. Y'all can tell me, and maybe I'm a little behind, but if your 5 attorneys are too busy filing motions to suppress, motion to get rid of all the evidence in the case, and motion to dismiss just one claim, I'm going to admit to it, but then when we go and we do the arraignment, I'm going to say I'm not guilty, but you already admitted to it in writing. I see why homeboy, I can't even think of his name right now, why he got off the case, because what are we talking about here? What was the purpose of this motion? Kimmy Locker, member and moderator of the channel, consultant paralegal of the channel, says, I know I'm tired of Diddy. And like I said, a lot of people aren't even covering it. And you're already tired of him, right? But he's trying, in my opinion, trying to get back in the media coverage. He wants us to be fought in the media. It's not working for him. Kimmy Lockett says, I think it was so crazy and front-loaded that most people think he's guilty and aren't surprised by any new information. I would have to agree with that. I think people are like, this has been a long time coming. Arrest him already. All right, he's arrested already. But put him in jail. Let us know how long he's getting already. I think that is where people are. Let me know where... my TikTok live just turned off. Let me see. My TikTok live just turned off because I guess I'm not commenting on it. That's weird. Oh well. Anyways, what was I saying? Let us know how much time he's getting already, because this case is not really going anywhere. That's how I feel about it. I could be wrong. I could definitely be wrong, but I think people just aren't interested in it because they're like, it's been a long time coming. He's going to jail. Deacon Fatal, thank you so much for... Uh-oh. Now I can't hear that one. Let's see. Trying to get my soundboard back together here because apparently that's not working here. But thank you, Deacon Fatal, for the $5 super chat. Definitely appreciate it. Saying I am way too, I don't know, to be worried about rich folks' issue. And Kanye was like, yeah, I like this. Oh, baby, I'm out. If I was a lawyer on this case, I would be out. I'll be out. He will be having to deal with a public defender because this is embarrassing at this point. This is very embarrassing at this point. Thank you for the super chat. Definitely appreciate it. Just Me MD says to Deacon Fatal, I was literally typing that rich people problems. It is rich people problems. It is for sure rich people problems, but that's what we cover on the channel. It's literally celebrity lawsuits. I don't know why this won't let me do anything. It just has like a black screen. But yeah, rich people problems will cover on the channel. I'm sorry, y'all. If we want to change the content, we can, because it's a lot. It's a lot keeping up with the celebrity lawsuits, but it is also fun. But let's go ahead and jump into the next part of this live stream, which is the motion to suppress every single piece of evidence. Every single piece of evidence that the prosecution has acquired in this case, Diddy wants them gone. Wants them absolutely gone. And they shouldn't be able to use anything because Diddy says that the warrants that was issued against him were too broad. They didn't have particularity. And now this motion is not as juicy, to be honest with y'all, as the motion to dismiss, because there's a lot of blacked out information. And I didn't really compare the two motions together because Diddy actually left in a lot more information than what it looks like the prosecution left in, which, remember, Diddy is the one that's saying don't let all the information get out there. But every time they file a motion, they leave in pretty much all the details. I don't even think I noticed any redactions in Diddy's filing, but there's several redactions in the prosecution's filings. And I kind of remember what the allegations are. So hopefully as I'm in the live stream, because when we're live and where we're reading in my bedroom, different things come to my mind, okay? So hopefully I can remember the allegations that are being made, because I didn't like make a chart and say, okay, well, this is what Diddy alleged and this is what the prosecution is blacking out. I didn't do that kind of comparison, but hopefully we can get through it. And like I said, it's not as juicy because the prosecution does block out a lot of the facts. So remember, Diddy is asking to suppress the evidence, basically any electronic evidence that the prosecution garnered by the warrants, because he's saying that the warrants were overly broad and they didn't include certain information that Diddy says would have basically showed that he was innocent in the case when filing the warrant. And we'll get into it. The prosecution is like, yeah, but we didn't know that information. You have to show that we intentionally misled the magistrate, the judge, in getting these. Let me just go ahead and close this, because this is getting on my nerves here. Okay, there we go. You have to show that we intentionally misled the what do we call it? Misled the judges when we did it. But if we didn't have the information yet, you can't say that we misled the judges. So let's go ahead and jump into the motion to suppress, because like I said, I don't think that they have a defense ready, and I don't think they're ready to go to trial. What I anticipate is that this May 5th date is going to get pushed way, way, way back. We got superseding indictments coming a month ago. I think there was like one a couple of weeks ago. I didn't really notice anything different in it, but I haven't had really enough time to sit through it and kind of sift and try to find the differences, because it pretty much has the original superseding indictment, the original indictment, and I didn't find like minuscule facts that were different, right? So anyways, I don't think they're ready to go to trial, so they're asking to get rid of all evidence against Diddy. All evidence, the 40 some odd terabytes of evidence and baby oil and everything against Diddy. Diddy is asking for it to be gotten rid of, and basically for the prosecution to go forward with none of the actual evidence that they received through the warrant. So maybe they can keep the video that they got from Cassie from her phone and the text messages that they got from Cassie from the phone, but they're basically saying that Diddy shouldn't be able to use any of the messages they retrieved from his phone or his iCloud and everything else. So let's go on. The government respectfully submits this opposition to the defendant's motion to suppress. In an attempt to suppress powerful electronic evidence of his guilt, the defendant makes two challenges to the search warrant authorizing the evidence seizures. Neither a challenge meets the demanding standard for suppression, and the motion should be denied without a hearing. The defendant first alleges that the government knowingly misled magistrate judges who authorized a search warrant by submitting affidavits containing false statements and omissions. The only thing actually misleading, however, is the defendant's repeated emphasis on what the fact finder would wish to know. And we made that comment throughout when we covered this case. Diddy, how do you know what the judges need to know? I think the best person to determine what the judges need to know is the prosecutions who do this on a daily basis, okay? Just because you would have liked to know that, Diddy. Luckily, you are not a judge. I know you would like to be the judge in your own case, but you're not. You're simply not. So the prosecution, again, is doing very good at calling them out of like, yeah, Diddy, you don't call the shots around here. What the fact finder wished to know, rather than on a well-established standard in the Second Circuit for evaluating intent. The defendant only prevails on his motion to suppress where the court determines that the material information was not included in a warrant affidavit and that the material information was omitted due to the affiance At the end, subjective intent to mislead or reckless disregard regard for the truth. Here he falls far short of the substantial preliminary showing required for both materiality and intent in order to justify further fact finding. The defendant's second challenge that the warrants are overbroad also fails. The defendant incorrectly argues that the warrants authorize the government to search everything in the defendant's cloud accounts, residences, and cell phones, ignoring the warrant's specific detailed categories for highly relevant information and materials to be seized, each of which was amply supported by probable cause. This alone dooms defendant's overbreadth challenge. But even if the warrants did suffer some defect, which they do not, suppression would nonetheless be inappropriate because of the executing agent's objectively reasonable reliance on the warrants. They go on to basically give us the counts, which we already went over in the other one. And then we're going to jump into the warrants that are being challenged. Prior to the grand jury return of the indictment, multiple magistrate judges and 3 federal district authorized search warrants for, among other things, the defendant's cloud accounts, his 2 primary residences, and multiple electronic devices as relevant to the instant motion. So January 2024, they allowed for them to get the iCloud warrant. Which basically addressed 3 different iCloud accounts: badboyworldwide.com, PD Team 69 iCloud, and then Diddy's personal iCloud account. Then the March 2024 premise warrant, one was in LA, one was in Florida, and it basically allowed for them to collect any evidence that would support the crime. And then we had one of his person on March 2024, which allowed them to search him personally, and then the devices that were on his person. And then the September 2024 warrant, which also allowed for them to search Diddy's person, and then also the hotel room that he was in and any devices, electronic devices that they found in those rooms. With respect to each of these warrants, the magistrate judge who authorized the warrant necessarily found that the underlying affidavit articulated both probable cause that the defendant committed certain subject offenses and probable cause that the relevant premises, devices, and accounts would contain evidence of those offenses. Some of the subject offenses listed in the warrants included racketeering, conspiracy, sex trafficking, travel, or enticement to travel with the intent to engage in illegal sexual conduct, obstruction of justice, and conspiracy to distribute or possess with intent to distribute controlled substances. So that in itself, the fact that they're charging him with so many things in itself is going to allow them to look in a lot of places when we're talking about doing a warrant. When you have a warrant where they're searching, it has to be reasonable that they will find what they're searching for in that particular space. And the fact that they are even looking up travel details and things of that nature, storage things, computers, phones, all of that would have the information that they are looking for there. If they're looking for using violence, using guns in order to coerce people and all the things, looking for guns, you can find that in the closet, you can find it under the bed, you can find it in the kitchen, in the cabinet, you can find it pretty much anywhere. So the fact that he was already being charged with so many things are already going to give them the opportunity to search through pretty much everything when we are talking about doing a warrant, right? Whether the warrant is reasonable. The defendant moves to suppress the evidence obtained pursuant to the iCloud warrant and the March 2024 warrant, alleging that the warrant affidavit together contained misstatements and omissions. The defendant further challenges the warrants as allegedly overbroad and insufficiently particularized. The defendant has not met the high burden required for a Franks hearing based on the purported misstatements in the affidavit. Remember what I said in the last one. He goes, oh, this should be suppressed. They shouldn't be able to use this evidence. Or, let me get a hearing. Let me see what their arguments are actually going to be. Sorry, y'all. I'm trying to get back on live on TikTok. Okay, there we go. So let's keep going. The defendant has not met the high burden required for the Franks hearing. In reviewing the magistrate's probable cause determination, the Fourth Amendment provides in relevant part that no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons and things to be seized. The magistrate's judge's probable cause determination is afforded significant deference by reviewing court. So you basically assume that the judge got it right the first time. It's going to be on Diddy to give information to the courts of why these warrants were improper. Diddy alleged false statements and omissions in the search warrants. A search warrant affidavit is presumed reliable. In certain circumstances, however, the defendant may challenge the truthfulness of the factual statements made in the affidavit and thereby undermine the validity of the warrant and the resulting search and seizure. Not every statement in a warrant affidavit must be true. To invoke the Frank's doctrine, the defendant must demonstrate that there were intentional misstatements or omissions in the search warrant affidavit and that those misstatements or omissions were material. The defendant must establish both components, intent, and materiality. I don't know why I can't say that word. So it is up to Diddy to basically show why these search warrants were improper. Let me see. I'm just trying to get past all the case law. Okay, now we are into the discussion. So it's up to Diddy to prove that it was intentional and that the omissions or the omissions were material. So very important that if they had included that information, the search warrant would not have been able to go forward, essentially, and that it was intentional when they left out that information. So the defendant fails to demonstrate that there were intentional misstatements of omission in the affidavits and that those misstatements or omissions were material. Sorry, y'all. To the contrary, the defendant relies on rank unsupported assumptions about the government's access to and knowledge of facts at particular points in time during the long-term investigation of the defendant's crimes. Moreover, and fatal to his motion, the defendant makes no attempt to show that the affiant acted with subjective intent to mislead the issuing magistrate judge or with reckless regard for the truth. His motion, therefore, should be denied without a hearing. The standard applied to the defendant is unsupported by law. The standard applied by the defendant is unsupported by law. Although the defendant repeatedly claims that affidavits contain material misrepresentations, the defendant identifies only a single allegedly false statement contained in the affidavits themselves. The defendant mainly relies on purported omissions that the defendant asserts should have been included in the affidavits. None of those alleged omissions, however, are material to probable cause. In an attempt to circumvent the Second Circuit's well-established framework for evaluating intent, the defendant relies repeatedly on his own standard for the kind of thing the judge would wish to know. Language taken from a Butsy citation from a particular case. There, the Second Circuit was highlighting the objective intent standard used by some other circuits on the one that the circuit declined to adopt. The defendant's attempt to lower the bar to obtain a Frank's hearing is contrary to the law of this circuit. Rather, to obtain a hearing, he must make a substantial preliminary showing both that the omissions were material and that the affiant acted intentionally or with a reckless disregard for the truth. He cannot do either. The sole alleged misstatement is not material. The defendant's sole claim that the affidavits contain material misrepresentation relies on information contained in the March 2024 warrant that the producer won, basically that they had the financial incentive and that they were suing him civilly. So the statement that I'm assuming who they're talking about here, this is my guess, is Rodney Jones. He made a statement that there were clearly minors at the party, but then some other people came out and said, no, they are 30 and they were not minors. And I'm assuming they thought that was who the minors were, but they were actually 30. I don't know. But they're saying that there was evidence that those people said there were not minors at the party, while the producer, who I'm assuming is Rodney Jones, said that there were minors at the party. And had the prosecutor included that information, or they did include it in the warrant, but they didn't talk about the other people coming out and saying that no, there were not actually minors there. So let's keep going. The defendant argues that producer one's statements regarding the minors, I'm assuming that's what they're referring to, were never credible, and that basically somebody came and contradicted it. But as described in the affidavits themselves, producer one's statements on the topic were corroborated by another witness relied on in the affidavits, identified as assistant one, who described also seeing, I'm assuming this is the minor situation. And like I said, Diddy left all of this information in his motion. That's the only reason why the minors are even coming to my head, because this was in Diddy's actual motion. But as you can see in the prosecutors, everything is redacted. So I'm having to guess what they're talking about. And the only thing I can think about that Diddy said that the producer, who I'm assuming is Ronnie Jones, lied about was that there was minors at the party, and that other people came out and said, no, there were not minors, or the alleged minors came out and said, no, they're actually adults. I can't remember exactly how it goes, but I think that is what they're referring to here. So that's the affidavit. The assistant said whatever that's redacted that we can't see, that the affidavits contain similar information from assistant one renders producer one's statement immaterial. Even if producer one's statements were removed from the affidavits, the evaluating magistrate judge could easily find probable cause based on essentially the same facts. So multiple people said it. Whether you think that Rodney Jones knew that his statement was fact or was wrong at the time, there was still someone else that said that there were minors there, an assistant that said that there was minors there. Moreover, even setting aside any witness observations, the blank, I'm assuming the minors, the affidavits contain more than sufficient evidence to find probable cause as to the narcotics offense. The affidavits catalog numerous witnesses' observation about the drugs. I'm assuming that word that's blanked out as the drugs, including the following. Victim one said something about it. An S worker said something about it. A holistic doctor said something about it. And I'm assuming they're referring to the drugs here. Designer said something. Assistant said something. The chef who worked for Diddy said something about these drugs. In addition to witness statements, the affidavit cited numerous text messages addressing blank, I think the purchase and sale of drugs, including, and look what the prosecution does for us. They redact everything. We can't see anything of what these text messages say. Remember, Diddy kept citing to all of these text messages that the prosecution had that they didn't include in the affidavit. So I don't know exactly what that's going to say. Or it's citing, is it citing the affidavit that, it might be citing the affidavit that Diddy's attorney filed, but I never actually read the affidavit because there's just too many words on everything. So let me see. I have it. Where did it go? I thought I had it. See, dismiss attorney declaration to suppress. Okay. Let's see here. Does it give a? And so yeah, theirs are all redacted too. I did look at this. I thought I didn't. So it's all redacted. So we don't even know what the actual text messages say because theirs are redacted, and so is the prosecutor's document. So there's that, y'all. So we don't know what the text messages say, unfortunately, because they redact everything out. Thus, setting aside both the producer one and assistant one references to, I believe, the minors, there remains sufficient content in the warrant to support finding probable cause as to the narcotics offense, rendering any purported misstatements from producer one immaterial. So remember, it has to be that the prosecutors were intentional in not including the information, and that the information would have been material. Had the information been included or not included, the warrant would not have gone forward in the way that it went forward. The prosecution has basically said, yeah, even if they were wrong about the minors, they were still right about the drugs. So they still would have got the warrant, is essentially what they're arguing here. The challenged alleged omissions were not material. The purported omissions related to victim one were not material. The defendant argues that the affidavit failed to inform the magistrate judge of basically the payout that Cassie received in her civil case. Specifically, the defense argues that the government was required to inform the judge about the civil case. And two, there was something else, how much she was paid. I'm assuming, if I remember correctly, that's what it was. The defendant's argument fails because these omissions do not defeat probable cause for ST or any of the other subject offenses related to the same conduct related to victim one, including the man act and narcotic offenses, and are thus immaterial. Further, the defendant cannot rely on second guessing the element of selectivity that is inherent in every affidavit to seek suppression of the government's evidence. The affidavit details that victim one's account, I don't know exactly what they're saying here. The affidavit also includes this, basically observing them doing the drugs and forcing her to do this and forcing her to do that. Let me see. Further supporting the action of probable cause. We don't even know what it says. So, so we don't know exactly what the prosecution is arguing. Again, indication that the prosecution is not arguing this case in the media, but Diddy is arguing this case in the media. Because remember, he left all this information in his, right? What he blacked out in his was what the actual text messages said. But even all of this stuff about paying them and the civil cases and all of that stuff going on behind closed doors, the prosecution is not including that. Diddy's trying to make these witnesses look not believable by putting these things out. Oh, they're biased because they got paid. They're biased because they're trying to get paid. Whatever his arguments are, right? Diddy's including all of that. The prosecution is not. And there could be arguments that the prosecution is not including that stuff because they want their witnesses to still seem credible, but also doesn't really have anything to do with the criminal case. That's up to the jury to determine whether these people are credible based on the fact that they have pending civil litigation claims against Diddy. That's for the jury to decide, not for Diddy to decide, okay? To establish ST, the government must show that the defendant knew or recklessly disregarded the force, threats of force, fraud, or coercion, or in combination of such means would be used to cause victim one to engage in commercial adult activities. A single instant in which the defendant used force, threats of force, or coercion to cause a victim to perform commercial adult activities act is sufficient. Relatedly, a victim's prior acquiescence does not preclude a finding that the victim was later compelled to engage in commercial adult activities through the use of force and coercion. And what they're referring to there, remember, Diddy is saying he is not guilty of trafficking these people because he was in relationships with them. He claims he was in a relationship with victim one, victim two, and victim three. And so since he was in a relationship with them, and since Cassie actually recorded the video on her phone and she looked like she was enjoying it. Yeah, this is the motion where he was like, oh yeah, she looked like she were. This wasn't the actual motion, actually. There was another motion of why it should be dismissed, saying it looked like she was having a good time, right? So there's no way she could be a victim because we were in a relationship and that's just what we did, essentially, and she wasn't being forced. That's one of Diddy's arguments here. And so what the prosecution is saying is just because she might have consented on different occasions does not mean that she consented on every occasion. And we are arguing that on this particular occasion, she was not consenting to it. So let me get back into this. Where were we at here? In other words, ST victims need not experience force or coercion during the entire period in which he or she is engaged in commercial adult activities. Accordingly, whether the defendant also engaged in non-criminal adult activity conduct during his relationship with victim one is irrelevant to finding a probable cause that he had ST'd victim one. All that is required is a finding of probable cause that defendant caused victim one to engage in a single instance of some commercial adult activities through means of force or coercion. And they did argue that. They didn't say like the whole relationship was invalid, but Diddy's argument seems to be with all the victims that end up coming forward is that they were my girlfriends. They had to do those things. They didn't push back. You know, we all enjoyed engaging in these group activities, group adult activities. Yeah, but if consent is not always, like if they say yes and then all of a sudden they start saying no, that no is what stands, not the yes that they said last year, right? So his argument is that, well, we were in a relationship, so they wanted to do it. Like what? No, it doesn't work like that. Thus, messages that the defendant argues basically said that they were in a consensual sexual relationship do not defeat a finding of probable cause that defendant committed ST. Omissions of such facts from the affidavit cannot be material. Like, yes, they probably did have a consensual relationship at some point. Does not mean that it was never any ST involved, right? Moreover, blank was potentially relevant. It's certainly not dispositive and required. This is where they're blinking it out again. Not required to warrant a Frank's hearing. First, if the affidavits included the alleged omissions, that would not negate the showing of probable cause that the defendant engaged in at least a single instance of commercial adult activities through force, fraud, or coercion. As set forth above, the affidavits contain detailed corroborated facts supporting probable cause to find the defendant trafficked victim one on more than one occasion. Second, the context that the defendant claims is demonstrated through his cited text messages is already implicit in the affidavit's description of blank. The affidavit detailed all of this stuff that they went through. A reasonable inference from the affidavit is that, I'm assuming, the relationship turned coercive at some point. Accordingly, the text messages presented by the defendant, that I'm thinking they're talking about the consensual relationship still, do not negate a finding of probable cause. Third, the excerpted text message that defendant claims are material omissions were cherry-picked by the defendant to illustrate his point about context, but in fact are a part of a larger incriminating conversation. So yes, although we do have those other text messages, Diddy, the text, the way that we painted it actually is supported by all the text messages you have. Remember, Diddy was pulling out text messages saying this could have an innocent meaning. It could have an innocent meaning, but the prosecution is like, but it doesn't. Like, read the text message. Stop looking at stuff through the Diddy lens. The Diddy lens is not a clear lens, okay? And I should know, I don't see very well. I know when lenses are clean or not, okay? So everything, Diddy is looking at everything through, oh, well, this is what I would think. Yeah, we know what you think. You think you can force people to do stuff because they're your girlfriend at the time. So you think the whole relationship is consensual. Okay, this fuller context further limits the probative value that defendant cited messages could have been negating probable cause. Between the messages identified by the defendant in Exhibit 10 and those in Exhibit 11 and 12, which we don't know what they say because they black them out. Nowhere in defendant selectivity more apparent than the messages that defendant cites. The defendant asserts that government intentionally omitted messages that basically keep things clear his name, but the defense fails to reference the messages that basically doesn't clear his name. They give examples that we don't know what it says because it's blacked out. Had the government fully disclosed the details of those messages, it would have strengthened a finding of probable cause. So although Diddy is saying, oh, well, they have all these messages, they didn't include them, the courts, or the prosecution's like, well, if we would have included those messages, it probably would have went worse for you. We still would have gotten that warrant because it would have made you look worse. It would have made you look worse, okay? Worse. Not better, worse. Okay. Even assuming arguendo, any of the omissions regarding victim one were material, the March 2024 premise warrant and the March 2024 person warrant set forth sufficient probable cause to believe that the defendant engaged in ST of other victims. The defendant ignores these facts altogether. As detailed below, the March 2024 affidavits demonstrated probable cause that the defendants used fraud and coercion to basically make these people engage in these adult activities, and he used force and coercion to do the same. Thus, even independent of victim one, and certainly when taken together, the affidavits provide ample evidence for the reviewing judge to find probable cause that the defendants committed ST. Finally, the defendant's argument concerning victim one, who we all know is Cassie, right? Victim one is Cassie, are directed almost entirely at ST subject offense in the warrant, even though the facts at issue are also evidence of multiple other subject offenses. The defendant makes no attempt to explain how inclusion of the alleged omissions would defeat probable cause as to those subject offenses, including, for example, the Mann Act, which is taking people across state lines to engage in prostitution, subject offense for which consent is not a defense. You can't consent to prostitution. You just can't do it. It's just illegal, okay? You can't consent to that. His argument is that these people were consenting because they were in a relationship. Well, the sex workers can't consent to the prostitution because they're not supposed to be doing that. It's illegal. It's illegal, okay? Indeed, the affidavits contain substantial evidence that the defendant transported others for the purpose of engaging in commercial adult activities. Similarly, the defendant merely mentions in passing that the alleged omissions negate probable cause of the racketeering conspiracy. That is far from sufficient to carry his burden. Indeed, the affidavits repeatedly mention blank, we don't know what it mentioned. As a result, even if probable cause were defeated as to the ST, and it is not, the evidence sought by the warrants could nevertheless be seized as evidence in violation of the Mann Act, racketeering, conspiracy, and other federal offenses. The defendant request for suppression must be denied on that basis as well. Remember, Diddy has 3 counts against him, not just the ST. Remember last case or last motion we were covering was a motion to dismiss the Mann Act, basically the prostitution. And this motion is ST cannot be found because we were in a consensual relationship. He finds one thing, my opinion, his attorneys and him, they find one thing and they focus on it. Lakes are hard. Try to make a good, compelling case for it. But a lot of times the arguments are not strong to begin with. The arguments are never strong, in my opinion, to begin with. And the prosecution just comes and tear them apart. Okay? United States Attorney, right? The purported omissions related to victim 1 were not material. And again, we're going to be dealing with a lot of blanked out stuff. As discussed above, aside from the iCloud warrant, the affidavits did not rely on victim 1 as the sole victim. The defendant argues that the affidavit's inclusion of blank is, I don't know. They said that's incorrect. First, the affidavits contain no identifiable omissions as to victim 2. The affidavits explain, for instance, that I don't even know. Second, the inclusion of additional omissions identified by defendant would not negate the basis for finding probable cause to believe that victim 2. The affidavits catalog more than dozens of examples demonstrating basically that he would be liable no matter what, even if they included the messages that Diddy wanted them to include, he would have still been guilty. That's the same thing that they find with victim 3 as well. I'm not going to keep going and reading the same thing of blankness over and over. The purported omissions as related to assistant 1, again, were not material. Essentially, even if they included the additional messages that Diddy thinks supports his position, they think that probable cause still would have been found by the judge. The defendant does not dispute. I don't know. Instead, the defendant argues that the affidavit's account of blank. I don't remember what this one is talking about. Setting aside that the government did not have this full thread until months after the challenge warrants were issued, which itself is dispositive of this argument, the inclusion in the affidavits of the full set of messages would have only strengthened the obstruction case against the defendant and his co-conspirators, and therefore cannot be material to the finding of probable cause. Again, basically saying if they included these messages, they still would have found probable cause and these warrants still would have went forward. They basically continue to say the same thing, honestly. Say the same thing over and over again. And then the omissions related to the civil litigation was, again, not material. Again, he's basically saying a lot of these witnesses had a civil case against Diddy. And the prosecution is basically saying that doesn't really matter. They are not informants who they would normally be required to prove that they have a track record of being reliable. They're victim witnesses, so their statements are going to be a lot different when getting a warrant than if it was an informant. I don't want to read that, so I'm just going to summarize that. So that one, let's see. I'm sorry, y'all. I lost my train of thought on that one. So the civil litigation does not necessarily make it so that they shouldn't be able to get an affidavit because they're suing him independently. Again, that is going to be something for the jury to decide. Are these witnesses credible? They do have a civil case, which Diddy's attorneys are going to bring up, and it's going to be up to the jury to say, okay, well, did this thing really happen, or are these people just interested in bolstering the claim so that they can get their check? That's the same thing that happened in the Hannah Gutierrez criminal case, right? Y'all have civil lawsuits for, intentional infliction of emotional distress, don't you? Some of the witnesses were asked those kind of questions. So they're going to do the same thing to these witnesses in Diddy's trial once it finally goes to trial. The defendant has shown no intent to mislead or any reckless disregard for the truth. Setting aside the failure to satisfy the materiality requirement, the defendant's request for suppression or even a Frank's hearing fails for the additional reason that he cannot make even a preliminary showing of an intent to mislead or a reckless disregard for the truth. On this point, the defendant relies solely on rank speculation and aspersions as to what the affiant knew and what the defendant believes the affiant should have investigated. Again, this is what Diddy would have done. This is what Diddy would have expected. But guess what, Diddy? You're not the judge. You're not the judge. But the Second Circuit is clear that more than defendant's mere conclusories showing of the affiant's subjective intent to mislead the court is required to obtain a Frank's hearing. As described below, many of the defendants' claim about government's knowledge and bad actions are baseless. Some of them are even directly contradicted by materials the defense had at the time of their motion. But the court need not accept government's factual proffers to find, as it should, that the defendant has failed to meet the burden of substantial preliminary showing that the affiant acted with an intent to mislead or reckless disregard for the truth when submitting the affidavits. For almost all of the alleged omissions, the defendant has failed to make any showing that the affiant was even aware of the information, let alone a substantial preliminary showing that he omitted the information in an attempt to mislead the magistrate judge. Nor could he, because the affiant learned of most of the allegedly omitted information after the affidavits were submitted. As to the other information that defendant claims was omitted while in the government's possession, the defendant has no basis to claim it was intentionally omitted. In particular, before the March 2024 warrants, the government was in possession of the content of, I think, his iCloud and a number of victim one's electronic devices that contain communications between victim one and the defendant, some of which the defendant alleges should have been included in the affidavit. The data totaled well over 1 terabyte, although the government had begun its review of 7 of the victim one's electronic devices and the iCloud before March 2024 warrants were issued. The review was ongoing at the time, and the warrants were authorized. So essentially, yes, they have the information, but they haven't sorted through it yet, is basically what they're saying there. Because of the ongoing review, the affiant had not yet seen the information that the defendant is claiming to have intentionally admitted. Of course, if the government was not yet aware of these text messages, the affiant could not possibly have omitted them from the affidavits in an attempt to mislead the court because they didn't even know the information. Indeed, the affiant's lack of intentional deception is apparent from the fact that the affidavits contain some information that we don't even know what it says. I think it's those text messages again. Indeed, the government was aware of the text message that strengthened its case, for example, blank. Because of the full scope of these messages would only have strengthened the warrant application, their omission could not have been made deliberately or with a reckless disregard for the truth. Similarly, the defendant claims that it is unbelieving and no accidental omission that the affidavit did not include certain messages. But the explanation for the omission is quite simply the laptop that contained the information had as one of the user profiles under Diddy's name, one of Diddy's aliases. As a result, and as defendant is well aware, the government obtained a search warrant before accessing the device, and the laptop was put through filter review as a precaution. The filter team did not release the information to the case team until months after the 2024 warrants were issued. The affiant had no ability to inform the court of the existence of the messages he did not know existed. In addition, the defendant also failed to show that affiant was aware of what he claims to be a complete thread between the victim and Diddy. Although the government had various screenshots of the conversation at the time, the affiant or the affidavits were submitted, the content in which were largely included in the affidavit, it did not possess a full thread until it extracted it from the devices 6 months later. In addition, the full set of messages only further support rather than detract from the government's showing of probable cause. Therefore, the chat's omissions do not demonstrate even a preliminary showing that the affiants allege misleading intent. The same is true for the S worker alleged the exculpatory information that Diddy basically says in there. And it goes through the same thing, okay? It just goes through the same thing. Anything that Diddy said should have been included. It was not intentionally left out because they didn't know the information. And even if they had known the information at the time to put it in there, it would have actually bolstered the warrant rather than taken away from the warrant. And that's exactly what it says. And I'm not going to keep rereading the same thing over and over. He then goes on to the search warrants being overly broad. They basically said that Diddy did not reach their burden in determining whether those search warrants were overly broad. So let's briefly go into that. Here, the warrants were meticulously particularized and amply supported by probable cause. Each warrant identified the specific offenses for which probable cause was established, described the places, accounts, and object to be searched, and specified the items seized by their relation to the designated crime. Thus, each warrant plainly satisfied the basic elements of particularity required for the traditionally understood. The defendant erroneously suggests that the warrants gave the government permission to search everything in the defendant's cloud accounts, residences, and devices, but a simple review of each warrant disproves the argument, which the warrant very clearly specified the items to be seized in detail. And one important part that we have to remember is this went through a filter team. So although they may have taken terabytes and terabytes and terabytes and terabytes of information and videos, things that Diddy had, the prosecution team does not see it. It goes through a filter team first, and then they give them anything that is not included. So they wanted anything that had to do with the fact that maybe he traveled or forced people to travel. So the filter team will go through that. They'll find plane tickets. They'll find text messages about traveling somewhere. They'll find those things. They take those, they give it to Diddy, and Diddy talking about throwing his mom a birthday party at Chuck E. Cheese. I don't know. That type of stuff would be excluded, and the prosecution wouldn't be able to see that. So another reason why this is going to fail for Diddy is that not only did they have the warrant to say, we want information related to this, they asked for the information related to this. They put it through a filter team to ensure that they only get the information related to those things that they're asking for. So I don't think he's going to be able to prevail on this. It's not going to go anywhere. I'm not going to keep reading the same thing over and over. That's the end. Okay. So he wants to suppress pretty much every single evidence that they collected from his home, from his phone, from everything that is basically going to prove his case. Because remember, this is the ST case. This is racketeering. A lot of the evidence is going to be on his phone. Some stuff from witnesses that are going to be able to testify to it. All of the things, right? But if he could get rid of this evidence, they have nothing against him. And Diddy's position as to why they shouldn't be able to have this evidence, it's just not strong. It's not strong. I don't think it's going anywhere. Y'all let me know what y'all think about it. I'm going to go ahead and check out those chats. I do see that we have some votes of, do you want to cover the Kim Kardashian situation live? And we are talking about Kim Kardashian threatening Kanye West that he can't use Northwest name because she owns her name, which is crazy. It's crazy because she trademarked it, right? There's going to be some issues with that. So we're going to briefly go over that towards the end of the stream, but I'm going to go ahead and check out these comments that are related to the motion to suppress the evidence. And then we'll jump into the Kim Kardashian trademark thing and why I think it's going to be an issue. And then we're going to peace out. This has been a long stream that I did not mean for it to be so long, but here we are. We are here talking about Diddy. Motion to suppress, I think it's going to be denied. I don't think there's going to be a Frank's hearing. I don't think there's going to be a hearing at all. The judges have wide discretion when it comes to issuing these warrants. I just don't see, although they could have included more information, always including more information does not necessarily mean that the warrant is not going to be granted. And so I don't think that the court's going to waste their time with it. I think that the court can see that Diddy is BSing, that Diddy's trying to do anything to get anything changed, and for him to look innocent in this, I just don't think we're getting a hearing on the motion to dismiss or the motion to suppress. Let's see what the chat has to say about it, and then we'll go ahead and jump into the issues with Kim Kardashian and her trademark of Northwest name. Okay, and she needs to be talking to her attorneys. But let's look at your comments. Deacon Fatal says the lawyer that left kind of lets me know something is off. Oh, absolutely. I think based on dealing with my own clients, when you have to file a motion to get off the case, it's because your client is probably being unreasonable, or the other attorneys on the case are being unreasonable. I don't often work with other attorneys on the case, but I can see how that can be an issue. And the fact that they filed that motion saying y'all filed this against me because I was Black, just one of the counts. The other counts are not because I'm Black. It's because I actually maybe allegedly did them. And not because I'm Black. The fact that they did that and that was a Black attorney, he got his butt out of there. He was like, you are not about to embarrass me. You're just not about to do this, okay? Deacon Fatal says, I remember they had a freaking tracker on his private jets for Diddy. I didn't know that. Deacon Fatal says, to me, I have forgotten a lot of this case. What music label was Defendant Combs under again? He's Bad Boys Entertainment. That's the one he owned. But he worked with other recording labels like later in life to produce that Love album, which I didn't know because I was not listening to Diddy at that point. So, but he owns Bad Boys, right? Kimmy Locker says to Deacon Fatal, pretty sure he owns was under Bad Boy, yes. But he also worked with another. I remember seeing that when we covered the Rodney Jones case. He had Bad Boys Entertainment, but he also worked with another production company to produce his latest album, which was strange to me, but who knows? I don't know how that stuff works. Shout out to Deacon Fatal. Thank you very much for the $20 super chat. Definitely appreciate it. Saying now this is just me personally. It's just my honest opinion. Keep the offender in prison till they are too old to harm again. I don't think Defendant Combs can be rehabilitated. That's just my personal opinion. I would have to agree if he is found guilty, because remember, these are just allegations and the government still has to prove their case, right? I think they have a strong case, and when more evidence comes out, we'll be able to see whether they have a strong case or not. Right now, we're just saying it seems like a strong case, but we really don't know all the evidence against him other than like the baby oil and stuff like that. I don't think he'll get out. He's already, I mean, he's not old. He's what, 55, 56, somewhere around there. But I think he'll get long enough. I think one of the charges he's facing is minimum of 20 years. Not minimum of 20 years, but 20 years. I think he'll be in there until he's expired. And I'm surprised this is not a situation where, you know, sometimes when these people go to jail and they have like a lot of dirt on other people, they end up unalived, allegedly by self-infliction, making themselves unalived. I'm surprised that hasn't happened yet. I'm not wishing that on nobody, but I'm surprised they haven't gotten rid of him yet. My conspiracy theories, okay? My conspiracy theories. But thank you for the super chat. Definitely appreciate it. Deacon Fatal says, again, trying. He is trying to avoid responsibility. I think so. He is trying to avoid. He's distracting. That's my opinion, is that he's distracting, okay? He's trying to distract from everything else that's going on in his case. Deacon Fiddle's gifted 5 Boss Attorney Bree memberships. Thank you. Shout out to you. Thank you for supporting the channel. We definitely appreciate it. Welcome to all the new members. Shout out to Deacon Fatal for gifting the Boss Attorney Bree memberships. Yes, welcome to the BriHive. Okay. If y'all haven't already, please do hit the like button. We're at 26 likes with 17 people watching live. If you haven't already, please do hit the like button. It does help us out. Now, let's very briefly, talk about Kim Kardashian. And while I'm doing that, Kim Kardashian, let me go ahead and pull up the trademark database for federally registered trademarks. Now, we've talked about Kim Kardashian on this channel before and how she is constantly filing trademarks, okay? And one thing that she and other celebrities have done is file trademarks for their children's name so that they own the name. They are the only one that can market products under their name for specific categories. And that is important, for specific categories. If you guys don't know what's been going on lately, as we know, Diddy has been in jail. Kanye West has released a song, allegedly. I haven't heard the song. It was released on Twitter. I don't be on Twitter like that, X, whatever you want to call it. released a song with Northwest on it. I don't know exactly what Northwest is saying. I haven't heard the song. And then it also has Diddy on the recording. And I feel like I saw some people say like Diddy's son is also in the song, or it was like a new artist or whatever it is. But Northwest, who is like an 11-year-old, I think she's like 11 years old right now. Diddy, who is in jail for harming women, and he has other allegations for child harming, doing adult activities with children, which is not allowed. And Kanye West decided he was going to include his minor child on the song. Kim Kardashian, while I am not a fan, she is making a smart move as a mother and saying, I do not want my minor child to be on a song with someone that is accused of these horrendous things. Now, has Kim Kardashian supported brands that have been accused of horrendous things in the past? Sure. And also affecting children? Sure. We're not going to get into that. That's not what we're here for today. But has she been in some sketchy situations herself? Yes. But is she subjecting her child to the sketchy situations? She's saying no. And she's saying that she thinks Kanye West is. So Kim Kardashian had her lawyer, as any smart celebrity would do, had her lawyer contact Kanye West's lawyer. And what her lawyer said, based on a tweet that Kanye West put out, partially a screenshot and part of the letter, Kim Kardashian says, I own all the trademarks to Northwest's name. And not only that, we have joint legal custody. So you were supposed to discuss these issues with me before you allowed for our daughter to be featured on the song. I don't think this is in our daughter's best interest. And then the letter is cut off. So we don't get to see the full letter that Kim Kardashian allegedly sent to Kanye West. Kanye West then also leaked some text messages that are allegedly from Kim Kardashian saying, you knew that I trademarked it. I talked to you about it when we first had our kids, that we're going to trademark her name, all the kids' names, so that no one else can use it, no one else can take it. Now, why would you want to name your brand Northwest? Apparently, Kim Kardashian thinks people are after them, and she didn't want to have to buy it from them. Well, I personally think she put herself in a situation where she may potentially have to buy back the name for Northwest, because while she did trademark it previously, she has let those trademarks lapse. And better yet, maybe you can say her attorneys let those trademarks lapse. Yes. So I think she needs to be in contact with her attorneys about making sure that her trademarks are revived, because they have been expired, some of them for 2 years. And no one is talking about that. They just saw the message. They say Kim Kardashian owns the trademarks. Yes, she did at a point, and technically in the United States, the first to use the trademark is the owner of the trademark. Yes. But in order to be protected federally under the trademarks, you have to have it registered with the USPTO. You have to file it consistently. You don't just get it granted in the States forever. Kim Kardashian should know that she's famous. She has multiple brands. She has multiple trademarks. She should know that she has to renew her trademark, and which she didn't. So let me see. I'm trying to pull up the trademark search system. There we go. And we are going to search Kim's a Princess, because that is the name of her company for whatever reason, which sounds just immature to me, but whatever. That's what she decided to name her company. And we're going to search all the trademarks that Kim Kardashian has. So let's go ahead and share that. Can y'all see that? I know people on TikTok can't see it, but the people on YouTube can see. So we got Kim Kardashian, we got dashing, dead. Y'all see this? The red marks, dead, abandoned. It tells you exactly what's going on with the trademarks. And so we see that she has one trademark for Northwest that is pending for toys, dolls, action figures, whatever. She intends to use that, so it's pending. It's not a fully granted trademark. But I will let you know, this is the only active trademark that she has for Northwest right now, and it is for dolls. Kanye West is releasing a song with Northwest's name as the artist on there. He's not releasing dolls, so he can use it. And let's keep scrolling. There is Northwest, as we can see, for entertainment. Remember, she's an entertainer. She's providing entertainment services. She's on a song. She's performing. Probably, maybe she needs one for music as well. But it should fall into the entertainment category. And what she had it for was entertainment in the nature of providing information by means of global computer network in fields of entertainment and pop culture entertainment service, namely personal appearances by a celebrity. So not even music. We're not even talking about music. That's what she originally had the trademark for. But if you look here, this trademark was abandoned and on April 3rd, 2023, which means that the trademark is no longer in place. Like I said, she needs to contact her attorney. It's not legal advice, Kim Kardashian. I'm not your attorney. Okay. She needs to contact her attorney because she doesn't have the trademark. She has the trademark by first to use it, right? She'll have the trademark for that first to use it. Or maybe it might transfer to Northwest if she's out there using her name, right? But she's the parent. They'll probably give it back to her, right? But right now, she does not own a federal trademark. So she can't get like punitive damages if she were to sue someone. She has common right to the name, but she does not have federal protection for the celebrity of Northwest. And again, remember, this is not particularly going to music, but entertainment, showing up as a celebrity. She's on the song as a celebrity. Those are probably going to cross over. She'll probably be protected even under this category. And why is this one? I think she just didn't file the renewal. It had to be that, yeah, because it was granted on December 2009. No, why is this no longer here? The trademark application was refused, dismissed, or invalidated by the office of the application and is no longer active. Why? Let's go to documents. She abandoned it. Oh, because this was also intent to use. So she never actually started using the trademark. So no, she doesn't own it. I didn't even look this far into it previously. So she never actually started using it. If you see the ITU, is that she intended to use it. And basically you can extend the intent to use every 6 months for a certain amount of time. She filed this in 2019. She probably just went past the extension window. I think it's like 3 years you can do the intent to use extensions. And she filed this in 2019. It was abandoned in 2023. So let's see. She never submitted a statement of use. And she did not ask for an extension for the intent to use. And I'm assuming she didn't ask for the extension because she already, I believe it's 3 years. I've stopped doing trademark law and I forgot. I think it's 3 years that you have intent to use. So she doesn't own it for entertainment purposes. She also had one for clothing, right? And this one probably got abandoned for the same reason, same thing, intent to use. She never actually started to use the name in commerce. So no, she does not own the trademark. Remember I said in California, the first to use is the owner of the trademark. But according to her filing status on the USPTO, the federal trademark database, she actually never used it. Had she used it, she would have filed evidence of use, and she did not. Oh, that's bad. Oh, that's bad. This other one is for advertising. What else? This one is for advertising services, namely promoting brands, goods, and services, and other endorsement service, namely promoting goods and services. Who wrote this? Commercial business, commercial information, global computer network, retail store service, gifts, consumer merchandise, apparel accessories, toys, basically like websites for sporting goods, beauty products, cosmetics, skincare. She intends to use this for Northwest as she gets older. So when she starts to make her own products, blah, blah, blah. But again, she ran the risk of filing it as intent to use. Somebody gonna tell Kanye West that she does not, and Kanye West, instead of going to check this, I think it's all for drama, y'all. It has to be all for drama, because instead of going to check this, Kanye West said, reverse it. You better reverse it. Sir, did you or your lawyer just not look into the fact that she does not own the trademarks anymore? Like, no one looked into this? No one looked into this? Oh, gosh. I looked at this the other day, but I didn't look that it was only intent to use. And as you see, she has her other kids here. Oh, sorry, y'all cannot see. She has her other kids here. Same thing with Chicago West. She let that one die. She let Saint West die. Not the actual kids, but the trademark. Sorry, that sounds bad. Palm West. All of these, look at them. They're abandoned, intent to use. She didn't actually use them, so she is not the trademark owner. Now, she can argue she is using Northwest number, her name in commerce by having her own TikTok and all the things, and maybe she's getting brand deals. I don't know. She may be able to argue that, but according to the federal trademark database, Kim Kardashian does not own the trademark to Northwest name or any of the kids' name because she let all the trademarks die. What is she doing? What is she doing? Can I, let's just look at all the live ones that she has. The only live one for Northwest that she has is the toys. And that's because it's still under intent to use. Oh, I might have to spread awareness. Should I spread awareness on this? Yeah, no, she does not own Northwest. She doesn't own it. She has an intent to use application app, but that has been expired. That one was in 2023. I think I saw another, all of them were in 2023 that we just looked at that already expired. So, trademark, she needs to talk to her attorney about the trademark because no, she does not own the trademarks. She does not. Sorry about that. And even she said she was going to file them when they were born. Those ones from 2019. I believe Northwest is like 11. I think, wasn't she born in like 2014 or something like that? The other thing is that she goes, I get to make, someone saying Kim Kardashian has primary custody. She gets to make all the decisions about the kids. Not exactly. I had their divorce decree at some point, but I don't know what happened to it. It might be on my other computer. I'm assuming it's on my other computer because I don't see it on this one. I did have I had the divorce decree, but Kim Kardashian in her own letter said that we have joint custody. That means that they have to meet and confer about making decisions that are in the best interest of their kids. So no, that does not mean that she gets to make the final decision of whether Northwest can be on the song. So what she needed to do when she found out about the song was to file a motion with the court and say that my husband or my ex-husband is putting my child in danger by trying to feature her on this song with Diddy, and she would have had to explain it to the court. I think I did see somewhere that she filed an emergency hearing and then Kanye West didn't show up, but I haven't looked into that, so I'm not going to really speak on that. But it sounds like she's not doing what she needs to do in the court. She doesn't own the trademarks. In my opinion, she does not own the trademarks. Like I said, they could argue use for like her social media accounts right now. But being that they are the parents, the court will probably find that they jointly own that trademark. And she said, oh, only one person can be the owner. That's not true either. You can jointly own trademarks. You just have to apply for it as joint owners, or what you do is you have a contract that basically says we are joint owners, and you file that with the trademark office. So her saying, oh, well, only one person can own it. That's not true. They can easily form an LLC together that they're both owners on the LLC, and the LLC owns it. Because who's owning these trademarks is not Kim Kardashian personally. Who owns the trademark is Kim Kardashian's corporation, not Kim Kardashian. So technically, Kim Kardashian doesn't even own the trademark. So all of this is a mess. I don't know how she scared Kanye West. I wouldn't be scared. I wouldn't be scared because she doesn't own the trademark at this point, at least federally, right? She has argument for common law ownership of the name, but at that point, like I said, it's probably just going to become joint ownership because they're both letting her do the so. I think Kim Kardashian is the one more letting her do the social media thing, but yeah, she don't own the trademark, and she doesn't have the right to decide solely whether Northwest can be on the song. The fact is, if she hasn't filed in the family courts that she didn't want her on the song at this point, if she tries to file it now, the court's going to be like, she's already on the song. It's too late. Why didn't you file this 6 months ago? Because it takes a while to get in front of the judge. Yeah, it's stupid. And Kanye West, instead of just talking to his lawyer, his family lawyer, his business lawyer, no one looked into this. No, she doesn't have the trademark. No, she doesn't. She absolutely does not. And then we got, what was I thinking? I can't even think right now. And then the final decision-making authority, she's already on the song. If she didn't file a motion before the song was released, what can the court do? The song is already out there. He can't unpublish the song. So she loses. She loses. In my opinion. That's all I have to say. I don't see nobody really commenting on this part of things. So that is all for the Kim Kardashian nonsense. I think she should really have her attorney look into that, because based on what I just searched on the Trademark website, she is not the owner of the name. The child is a minor. They can both use her name. I would, if I was Kanye West, I would get some type of LLC formed for the kids, because your kids are going to be celebrities, and have that LLC separately own the names, not one of the parents. And like I said, it's not true that only one person can be the owner. Multiple people can be the owner. You just have to have the contract and have it filed with the USPTO. But like I said, there's not even any trademarks other than the toys intent to use. And last time I checked, there's no Northwest Barbie dolls coming out. Maybe there are, I don't know. But yeah, no, she kind of lied, and he just didn't look into it. Which is very interesting to me, for them to be celebrities and have all of these lawyers. She just lied, and he was like, reverse it. He's like, dude, did you not check? Why would you not check? If I was telling you this, I would go file the trademark right now, because they're already abandoned. I would go and file it in a different category than the toy category, because they are abandoned. Almost 2 years abandoned. I would definitely go do it. Oh gosh, Kardashian. I can't believe no one looked into this. Tanya D, or Destin B says, I can't wait to see how this plays out. Me too. I wonder if they have not realized that yet. Like, or maybe again, I think it's Diddy trying to just get more attention on his case. But like I said, that didn't even turn into like a big thing either. And maybe because they know she doesn't actually own the trademark, and she doesn't really have any legal custody rights, because remember, the child is a minor. They're supposed to be making decisions in the best interest of the child moving forward. Now she can ask for it to be removed, but she's going to have to prove why her being on this song. It's not like she was in the studio with Diddy. It's not like, come on. You're going to say, well, even just her name being associated with her, that wasn't the best move for our daughter. Is anyone talking negatively about Northwest? No, they're talking negatively about the parents, arguing in the media about whether she should have been on the song or not. So she's like, she's thinking about filing a motion to get him taken off legal custody. Removing a parent's legal custody rights are very, very hard to do in California. Very hard to do in California, especially if he's active. Okay. Just because you let her do something or he let her do something that she didn't like, I bet you then Kanye West is going to bring up everything that she's letting her do. She got her on TikTok. He didn't want his daughter on TikTok, right? He didn't want his daughter doing the Disney stuff, whatever. I don't know what the heck she's doing. But remember, he had that whole rant. So the risk that she runs trying to take this to court and get him removed from legal custody, he's going to bring up that whole TikTok account, okay? And the people talking about even thinking that she's dressed inappropriately and all of that stuff. And then the court's going to put out an order. This child is not to be on TikTok without approval for both parents. They don't want to do that. They're not going to do that. The joint legal custody means they have to make the decisions together. And if she goes and takes this to court and complains about whatever Kanye West is doing, he's going to complain about what she's doing. And she does not want that reign taken away from her. So that's the end of that. Kim Kardashian does not own the trademark, especially under the federal. It always said intent to use. She's never, from what I can see, put forward a statement of use. And remember, in the United States, the first to use the trademark is the owner of the trademark. She had this pending since 2019 and never filed a statement of use. So I think it's going to be hard for her to show that she has actually used the trademark and is the owner of the trademark back to 2019, back to 2014, back to whatever year she's trying to prove it. Because if she could prove it, she would have filed a statement of use and she would have had an active trademark. She is a celebrity. She has multiple trademarks. She has multiple trademarks that are registered. Registered, not pending. She has registered trademarks. Skin by Kim is fine. It's registered. Skin by Kim is registered. KKW, that's registered. All of these are registered. Why is your kid's name not registered while you're sending a cease and desist? Why you are sending a cease and desist letter to him saying you're the trademark owner, knowing that all the trademarks, except for toys, have been abandoned, and you never submitted a statement of use, you don't own the trademark. And I think that's going to be a very hard argument to make. The legal custody argument of making the decisions for the kids. I think that's going to be a very hard argument to make. She files something, guarantee you, Kanye West is going to file a retaliation. I don't want my kid on TikTok then. I don't want my kid on TikTok. I don't want them at events. I don't want them unless both parties agree. Destined to Be says North West is going to emancipate herself at 15 dealing with these parents. Right. She's going to have to. She's a celebrity child. She wants to be a little bit more into things. She's definitely more of the celebrity of all the children. I mean, she is the oldest, so that makes sense, right? She's going to want to be free for them. I wouldn't be shocked if that happened. They can't get it together. Neither one of them can file nothing with the custody court, because then neither one of them are going to be able to do what they want to do. Neither one of them are going to be allowed to do what they want to do. Anyways, that was my rant on that. I'm done. I will see y'all all on the next live stream. We will be doing Reddit reads tomorrow with the celebrity stuff. I am really thinking about changing the content on YouTube. So I'll probably put out a poll on my comment section. On my community post, and still kind of cover celebrity lawsuits, but I think it is kind of hard for me to focus on celebrity lawsuits. I told some of y'all previously that I am switching jobs, so my work times are going to be a little bit different. I think I may even have to stream later than I'm already streaming if I'm going to continue with the weekday streams. So I am considering changing my content to something that is a little bit more lighthearted, that I can kind of clip a little bit easier, because I've been wanting to do more clips and things like that. I don't know if y'all really care about YouTube strategy, but just to let y'all know, there may be some changes coming with the content that I'm putting forward, moving forward. So anyways, thank you all for joining me. I think that Diddy's motions are not going to go anywhere. I think that the Kim Kardashian, Kanye West thing is not going to go anywhere, because neither one of them owns anything. The Northwest name. Either one of them can really do whatever they want, and they're not going to file anything in a family court, because then it's going to stop them from doing what they want if they try to stop the other one from doing what they want. Putting her on the song, is it inappropriate? Probably. Is it really putting her in danger? Not really. People are more talking about them than the association with Northwest on the song. It's like, why would you associate your child on the song? And then Kanye West can argue why you got our daughter dressed like this on TikTok. So either one of them files something. This is not a violation of court order. It's going to end up where he's going to get something taken away and she's going to get something taken away. They're not just going to take away stuff from him. But anyways, I will see y'all on the next live stream, which is tomorrow, Wednesday. We'll be doing Reddit reads. I don't know what the topic is going to be yet, but we will be there. I will see y'all all on the next live stream. Have a good night. Bye.